94.7 Asempa FM. Ekosiisen dwumadi no asoguso a wotie no. Ye na munyina ase adofonom esan mamu akwa aba bieu. No nsia ne fa bo a na ye dwumadi eba awie ye medi ndi osaibo nso nti emraso ye beje reactions said the amamo some messages now we say good afternoon Obi. In fact, lawyer Akutuampa is truly a great lawyer. I wish General Mosquito is kept in the box for the rest of the week. Gusty man is in Brekum. In the Bono region and on the way Abrewe said to me, this election petition will come to an end earlier than the stipulated time because the first cross-examination has settled the case in the sense that Mr. Asirin Ketia has admitted that he doesn't know the total vote Mr. Mahama, the petitioner, got, and that of Akufo-Addo as well. This means the sole evidence will be that of the EC's declaration result, and that result clearly shows that His Excellency Akufo-Addo has won. Okro Yeboah is in Breman, Benin, and Oduya. But good afternoon, Obi. I just want to know this. Is the NDC saying they don't have any independently verified result from the 275 constituencies of the country, or is a legal tactic they are deploying in fighting this case in court? It's a bit confusing, and I'm sure I am not the only one with this state of mind. Abraham Lincoln is in Koforidia, the Eastern Regional Capital. Coming through with this one. Hussein Salifu is in Kaswa Zongo, and he says, Obi, I think it's high time we looked into the eyes of Mr. Mahama and his legal team and told them that they are wasting our precious time. Some of us are using part of our working time to follow the court proceedings. Meanwhile, there is nothing in their case. Hussein Salifu in Kaswa Zongo. Obi, we are glad today the witness for the petitioner's calculator worked perfectly for him without any errors. All his calculations proves President Nana crossed the threshold of more than 50%. Regards to Honorable Frank Anodompre and a belated birthday to Nanaya Okese, aka the Cardinal of Peace FM. Eric Dankwa.
Ekosiisen on Asempa FM.
Dobro. Okay. Let me see the other ones here. Lawyer Akoto Ampao. Okay. Also, lawyer Akoto Ampao is tactful and knows clearly what he's about. What I'm learning from his cross-examination, and actually is the case that law is not about flowery and long grammatical argument, but persuasive statement with evidential value. Kudos to him. Kwesi Reynolds, Agona Odobe, Joseph Akable, court correspondent. Joseph Akwaba na pom te saying. Great. Enti en boyemu, what has been happening? Ewo Supreme Court ene.
The main issue will be PMO and Johnson Esiedu in Ketia, or NDC General Secretary. No, or no, now Obejina Adakam testify on behalf of John Dramani Mahama or the petition here, Abedan in court, Nakachino. Now, even at the start of proceedings, no court, no, it raises some issues about some of the lawyers in the case. I thought that not a phone court or much me a granting interviews any other. And at the point that the court is making is a Legal Professions Act, no, indicates we are lawyer, we are counsel on record in the case, and the amount of coins say a granting media interviews related to that particular case. No, it's the first judges, no, chief justice in your Okasafa one, and in it was referring specifically to a Frank Davis, or a lawyer on record on behalf of the second respondent. And that was the first issue at the court, no. A daily week.
In the meaning, say court na catch from say after proceedings, the moment granting media interviews bill.
Or say a lawyer on record.
Okay.
In this instance, the lawyer on record refers to Akoto Ampao, Frank Davis, Yao Opon, and Afesu Kweku Esirfi.
Okay.
And for the Electoral Commission side, no, it refers to Mr. A. Sumwa Samwa, our representative Electoral Commission, and I think so Justin Amenovo. And in terms of President Mahama's side, it refers to the Mr. Chatuchikata, and I think so Tony Lita.
Tony Lita.
Lawyers on record, since you're moving to another court and refer to.
Okay. And what it means is that any pa ya bone, you know, court na catch her on says we proceedings or mono, they should not be granting interviews. Or mama other lawyers saying yeah.
Ekosiisen on
Okay.
Asempa
We're in
FM.
line with the requirements in the Legal Professions Act. Eba or more from granting such interviews.
Okay. Yo. In the no training at the MBC.
Generally, John Special in Ketia, Eberua, a year witness box anymore. Almost started with cross examination. A comment or a year Friday. Now, the cross examination first, no more the kind of a year videos a year show you a in Ketia, any other top officials of the NDC, including the party's flag bearer, Namwa, John Dramani Mahama. Another point, Mr. Kotampa, and make it to honor say they had made comments which suggested that the NDC presidential candidate had won the 2020 elections. And even though some will make those statements, no matter PM or court na catching in Kratom or better in court indicate so Mama Gimone there, Obia of course 50% mark na HSA Obia in winning election. And then the crux of the cross examination today, and Mr. Kotampa after a year is in a declaration of results December 9. Obekaya Electoral Commission in announcing the total valid vote cast. Omobo the figure of
Ekosiisen on
13.4 million
Asempa FM.
instead of the figure of 13.1 million. Correct total valid vote cast. Omobo total vote cast as the valid vote cast. Now no is in a person is in a holding on to it. The Mr. Kotampa here and say Oma a calculator and after your car says Sadia would you put it together figures now electoral commission chairperson or assign it to each of the candidates or this okay cast our figures ni boom na we coming to the conclusion say ubenya 13.1 million na or no insist say and then the right figure now on the face of it is obvious that the EC chairperson made a mistake. I want to mistake in Ketiaka say or say EC chairperson and make it a slip or not. But in terms of the calculation, he agreed there was signing each of the figures is in the various candidates in that December 9 declaration. All the candidates, okay, Kabuma, and remember 13.1 million as the total valid vote cast. And see, and then computations relating to adding the Petition South constituency results to that figure of 13.1 million and assigning the various candidates to the specific votes that are more obtaining with Petition South and computing the percentage of it. And in each of the case, the figure that Mr. Ketia calculated ended up giving the second respondent more than 50% of the vote cast. But Mr. Ketia insisted that operates on the assumption that the EC's 13.4 million was in error, which is something that he holds the view that was the figure that they announced, which does not make mathematical sense, which actually means that no one got more than 50%.
Okay, and based on that, no insist say 13.4 million was not in error now, and only the right figure is declared.
As far as we're concerned,
I know you're concerned, no.
Boy, we have calculation now, and then they just say, obey more than 50% of the vote cast.
Okay. And a free honor, and I would want to believe, say, lawyer Akutampa also put to him, say, that 13.4 was in error. Now the right one, 13.1, and that's why some more added up figures will be in here. It amounts to 13.1, right?
That's perfect. Now the response on my end is he wouldn't know because as far as he's aware, the EC has mentioned the total valid votes as 13.4. So I don't know the energy mana and then the case say obi more than 50% of the vote cast.
Okay, and no was the summary of cross-examination in meboa. And Obabe I recall say from the bench, justices never so ebusa questions be.
Specifically, Justice
Apple, okay.
Or not Chief Justice on the right hand side. Questions are beside Mr. Seni Ketia Kasa Afa the Electoral Commission akeka bom no bisa ne say on one kasa no okeka bom no onima hia petitioner no enya ya na then no na Mr. Seni Ketia Kasa they don't to me and responded to that issue. And see the other questions also related to the percentage too. and it's all the same response. And only after any president, the legal team, up to now, Mr. Mahama side, I'm going to make on mine how many votes are in their own estimation. But those were the questions of Justice Yawapel beside the close of proceedings. But besides that direct question to Marita be appear upon our Casa on behalf of Mr. Mahama team at the close of proceedings. Now, on no instance, they said, as far as they are concerned, they opted to challenge the declaration of the December 9, and that is how come they put together evidence that challenges that particular declaration.
Oh, okay. And the just hormone and yet your friend say more calculation be on my year and on the air back court in summer easy na can on the 9th of December no mujina so back court no.
Now, in fact, Mr. Shenin Ketia, even during cross-examination, he was consistently making a point that among back court somebody declare more results because NBC Amanyukun and declare results. East in a declare results. The East in a declare. And then Omujina so Ediabadan court Nakatia much said there's internal inconsistency in that particular declaration. We analysis now or indicates so will be more than 50% of the vote cast.
So, utie how a cross examination no occur from Friday ever be see and because you say in hearing the case no the see yeni so neoma hodo be enum the 5 main issues are court no a determine as far as this trial is concerned no number 1 whether or not the petition discloses any reasonable course of action. Number 2 whether or not based on the data contained in the declaration of the first respondent and the second respondent, as president-elect, no candidate obtained more than 50% of the valid vote cast as required by Article 63.3 of the 1992 Constitution. Number 3, whether or not the second respondent still met the Article 63.3 of the 1992 Constitution threshold by the exclusion or inclusion of the Techiman South constituency presidential election result. Number 4, whether or not the declaration by the first respondent dated 9th December 2020 of the result of the presidential election conducted on the 7th of December was in violation of Article 63.3 of the Constitution. And number 5, whether or not the alleged vote pardon and other errors complained of by the petitioner affected the outcome of the presidential election result of 2020. And when 5 issues, cross-examination and Ujidi said they were all targeted at answering our questions way.
In fact, the whole cross-examination is centered on these 5 issues, but it all boils down to what the court will hold as to whether or not on the face of the declaration that is in making, whether it indeed made an error or not. And I say during an actual total valid vote casting because Mr. Kutampa on analysis say or ye be a Techiman South if you want to be all the Techiman South eshemu and I think so or sign put it together the second respondent in terms of they are signing man and the other candidates to analysis. Next largely media all the factors that took place no it sought to attack Mr. Stephen Ketia's testimony relative to 5 issues here.
5 issues, right? Wow. And this is here and Abawi Ochana, another witness be mount box no witness be
Dr. Michael Pesa White now one of the 2 representatives Mr. John Mahama se onko jina Electoral Commission National Coalition Center the FN is strong room no onko jina ho and the observation and yemesi ko on no and about testify the witness statement no yeni edukan ehu bi the witness statement make the point say in the course of the coalition na course wo strong room on mo detect some mistakes na results ni man no mo collect na mo prompt each chairperson and any each chairperson according to Dr. Pesa White e ka say omon kono ni
Ekosiisen on Asempa FM.
Report back to ono. No say embre omo kodu Mr. Mahama ni fie ho no. Omo right side on no hu say EC chairperson e wo team so a o declare our results. It's Dr. Michael Pesa White ono and about begin that candidate na testify.
Oh, okay. Not just no bar. We would see easy lawyer no cross examining him. Now we are akutwampa also cross examine no. And we hope say ochina no eno no bebe wie and the next witness ebe Mark Menu and say Charlotte your friend is saying Jean Mensa. In the Jean Mensa beba first. Okay.
Now and
Mark Menu aba.
It is a easy chairperson by it means that the cross-examination will be by Mr. Muhammad's side.
Yeah.
As well as the president's side if they have any questions.
Yeah.
Now for Mr. Masmino Baswa and then Mr. Muhammad's side no. And as the
electoral commission side the cross-examination.
Then there's another barrier and there. Then the court would have to direct the lawyers to file their
written submissions, no.
Na court na fix dates to deliver the judgment.
Okay, we are hoping, sir, cross-examination because enmity Chief Justice okay said as far as case management was concerned, Mama almost said they would spend a day on each of the main witnesses, no, right? And not just say
the court on its own decide say or to me I extend
or the days in the cover.
And yes, I have videos and some now every PM on Friday. I can't be crap. I can't be to me.
I see you don't get Friday.
But I mean, obviously, the 80% of the can India, and then we can expect a understand Mama and sign it or maybe some questions. Yeah.
But plus or minus, by the end of this week, the trial in open court would come to an end.
That's the expectation of a lot of us following this particular case.
Yeah. Okay. Joseph, my nase na and mpanyifo na timi PM wo court no. John Muhammad timi bai.
There be was in the PM.
Okay.
Johnson is here in Kitia. And a beginning mo a man and I think so. Peter Masmenu sending Mr. Dow and another Akufado. On obedient a man.
Okay. Joseph, my nase na fancy bibia ni ebesia be din komo bio. Why? Yeah, that's the part. Joseph Akable reporting live from the Supreme Court of Ghana. And Medicare catcher must say issues are and despite their course so before set trial neighbor here last Friday, you know, Supreme Court net na say ka say asema that court no in some misahud wo be num and a yewie bibia was a court ne hwe eyi ano into the matete back and forth argument akoso from time sa trial we shall say in fact even before case management near the didn't same course nyina argument way objection way document way anye way ebeje ni nyina no court na set down 5 issues it is assembly nyina area sa issues 5 na court na ehwe yi ano in the obia cross examination na oye emfa ho ne question na wobusa e wo se ni nyina hwe eyi sansem num a medical akan no ano entimu nyina mo nhya ne so emfa emayen and that is the focus as far as this petition is concerned. Ma main kind messages kakana fi enhwe to aso witness I say don't get inconsistencies. The lack of candor in this case is mind-boggling. If witness in Ketia doesn't know the votes garnered, the votes JDM garnered, then on what basis are they in court? Poor letters of deceit and deception indeed. That's from Farouk, and he is in Tema. Okay, Farouk is in Tema, and Odiwe Abdul Karim. Or say now the case is getting interesting. The NDC went to court with a conjecture. The time to provide has come, and to our surprise, they don't have a single evidence to buttress their claim of the EC rigging the election for President Nana Addo. You can't do propaganda in court. The fact and evidence will expose you. Abdul Karim at there, and on Abdul Karim, I mean to say, sir, omuni evidence. No, the case has just started. Let's take time. Fawaz Wamba Samana, for me, the 3 intelligent questions from the bench is what will knock the whole case. Fawaz, Amasaman, Fawaz, and on the way up. We say, and even if there were errors of whatever nature, scope, and coverage, did their impact materially affect the integrity authenticity and credibility of the declared results by the EC. This is a factor. Okay, this factor is considered a critical factor in determination of election petition litigations. Inti Abdul Malik Kwekubako edia odia beka hono lawyer nana eje bafo ewa private legal practitioner ma meneno eni enkomo on enedi onu nso hu from cross examination a course so and where we go from here. Lawyer akwa ba Ekosiisen so ne bibia boko de
ye nyankopon adaro man pa chona so e
nyame adom ye nso ye ho ye papa ye da se watimi age ye nso enne megidi se utimi ehwe proceedings in the Supreme Court from where you sit nioma ko san ma
say nioma mienu bi na di na make out in the form of a question so that I do not, and yes, I mean, we could book out here. The first question is whether or not the petition before the court even meets the threshold of an election petition. So,
okay.
The court Article 63, Clause 9 of the Constitution, or say you tuaba na say results na bede you na abato no o pese o challenge ya o file a petition. So the Supreme Court in a previous decision aka say adia ebetimi amwa file election petition. So, and it's all challenging the validity of the elections. And so the first questioner, they say, whether or not the petition before the court is to challenge the validity of the elections. And we are one. That's what I said.
PTO lawyer.
And now the second question is say, validity of the election.
The article you quote, a lawyer, 64-1 rather, right? 64-1.
64-1.
Yes.
64-1. Sorry.
Okay.
No
problem. No problem.
Me sorry, pa. 64-1.
Yes.
And the facts are there. And the answers are petitioner no witness edema. Or can say they are not in court to challenge the validity of the election, but the constitutional obligation of the chairperson of the electoral court, first respondent.
Mm-hmm.
And no one will be sound say, is it the validity of the elections of more courts or more challenging? And when it seems as any answer may have resolve it.
Interestingly, and also 5 issues Supreme Court set it down for the trial, no, and I said for determination, and only number 1 issue. Yeah.
Now the second and then so they didn't say we share questions justices need be say na say intriguing for me. Some questions, and only the heart of the issue before the court. And so court, na say trial. Trial it is governed by the Evidence Act. Now Evidence Act, at each material moment, why we make allegation be, why we make allegation, we want the burden of proof. Me patro te ase.
Me patro.
Enti si bisa o say munni figures be. Now ka se there be ye figures be a problematic.
But say would it still be problematic when nipa na indicate say wa ma court with figures and if omo figures in no more court in some electoral commission nankasa the trigger no more court.
A honon so any question ba ko a say sadia Nastela omo petition no meet the threshold of a presidential election petition. If I short I say,
Me too.
Say, the declaration of the elections, is not the same as the validity of the elections. The case of Roger Metal versus the Electoral Commissioner. Sabreno, Nayenra Tony Lisa, on a lawyer for the applicant, for the plaintiff, because now a high court matter. Anna, almost forward day, constitutional issue, because Supreme Court, say omunko answer. Me patriote I say.
Me patriote.
Na edu Supreme Court ono. Yera Tony Lisa ji tumu Supreme Court and say Oba ma me challenge the validity of the elections. They came to challenge the validity of the declaration. Intihono Supreme Court ji tumu say yera datema or ji tumu say. So when you are not challenging the validity of the elections, it does not constitute an election petition. So I say, Yera Tony Lisa, or Tisadi na Sintino, while filing election petition, neighbor of filing a rate or high court. Me patriote I say, or you tumu, or no one kasa you tumu say, a sense no challenging the declaration, right? They're not or they are to Supreme Court anymore. And yet elections petition.
Baba, in that specific case you refer to, sir, later court they catch you on for petition, bro.
There be court nanka son for petition, bro.
Okay.
Court nanka son for petition, bro.
Okay.
The acquire any say. Na almost say the declaration of election, the declaration of president-elect instrument under Article 63, Clause 9, it does not capture the details of the results. As far as they were concerned.
Okay, you are referring to Roger Metal, 2004.
Roger Metal,
Okay.
As far as they are concerned, essentially say the declaration of president-elect instrument and capture the details of the results, right? Unconstitutional. The patriot say.
Yeah.
Now, and the Supreme Court catcher almost say, yes, ideally, sa instrument say a containing results are a but as the Electoral Commission has indicated, the results are declared at the polling station, collated at the collation center, and so the records are in the public domain. It is anymore and say the patriot say. The Supreme Court then said, look, the declaration of elections, challenge it does not amount to an election, a challenge on the election, because it is not a challenge on the validity of the election. The patriot say. It is a to say, challenge is no media on the basis that she has failed in the performance of her constitutional duty. You are not challenging.
Meaning, sir, any reasonable course of action to go to the Supreme Court. I get you with an election petition. No, sir, and on me, in the 64(1) of the Constitution, the validity of the election of the president may be challenged only by a citizen of Ghana who may present a petition for the purpose to the Supreme Court within 21 days after the declaration of the result of the election in respect of which the petition is presented. And interestingly, in a way, any issue number 1, whether there is a reasonable course of action for even this petition in the first place.
So Supreme Court be answer based on a answer or the in the witness box.
Now, would it be based on a Sedun Ketia answers and now subsequently witnesses or Monso can inform?
Well, witnesses are Mobeba, but you see, one was a catcher will say, when you go to court for a trial, hearing is governed by the Evidence Act. Into say no, so movie the court no ebe ka adansi a mwedi nyina boom. So what I say, ni ebisa ye ho say, wo petitioner no, wo na wo burden to prove the na wo kan. So what I say, into wo frɛ wo witnesses, ba ko ni ewura esiedun ketia, ba ko ni ewura pesa white a obeba. Ye ka omo nsɛm omo bɛka yesi animu a. One, nsɛm a bɛka utimi prove ya na. Ɛno yɛ one. Two, say impose say utimi prove ya. Does it even disclose a reasonable cause of action? The pastor say.
Yeah.
And then the third fact they say, even if you were able to disclose a reasonable cause of action, right? Is your cause of action one that constitutes an election petition? Assume he said the declaration was wrong, which is what that Eba even said in Rojono Metal, which was to the effect that say Yajitumumpo say the declaration here wrong. All we would need to do would be to let the electoral commissioner to go and do the redeclaration. The underlying elections, is not affected. That's what I say.
Yeah.
It is if the underlying elections, right, is not affected, well, are you challenging the validity of the elections? That is the question. And on the questions now, Justice Apau, Ebisa or Mono, are very important. And so even if the declaration is problematic, can it lead to the change of things?
Okay. Lawyer, I get your point now. Did you see how you're trained in Yame Yadomo Echena, and so ebeba. Me kaisa time lawyer Kutampa we and lawyer Tajuchi Kata sorry say or non so here re-examination. But I say obusa for clarification be from the witness say you can't inconsistencies in the figures now. The Abasa Kutampa had issues. Adain.
I'm a patch of one. Say, we are cross examination. We are the other side, that is the counsel for lawyer or counsel for witness or another came or who quite so be question. They move very limited, and no, you find a re-examination. The patch what I say.
Yes.
Now re-examination, you can only re-examine on BBA ambiguous. The part what I say. It is the another rakutampa air can say. Adiana will be sano. A self-explanatory. It is ambiguous in here. Oba baby samwashem. So, but let me tell you something, my brother. Election petition way is an enhancement over the year in 2012. And I'm sure say here quite a nimno and yama be brave because Osha Yana me so say Supreme Court judges of when you in terms of procedure nomnia there because Osha Omoka say Onjai Yuracha Tuchikata no misa question. So that they didn't even rule on whether or not question na obisan ambiguous. Because even the filing of witness statements, it is my humble opinion that it should be with leave of the court. And you're automatic. So election petitioner, presidential election petitioner, and yet the writ of summons. Writ of summons was summarize it one was now the good statement of claim with the hope or with the expectation saying trial your witness is going to expand on the summary the statement of claim now social presidential elections petitions it is supported by an affidavit which in itself is evidence and the affidavit is supported by exhibits. So, to call witnesses to come and testify, it should be on a point that necessarily needs clarification. And that requires leave of court. Into calling of witnesses to say they are free as you're doing Ketianum. You have a free person white. You have a free Ramakman. It is not as a matter of course or a new automatic. But what I say now, Usha as a Supreme Court, and Omo Sabi acquire Ghana ama your semonomia DNT. Omo pese obibeka sebia omo ye bias anabibi ina omo ankasa agoniemem. So into Usha as a niema bebre mu agopa but nka omo di the rules of procedure here was ebi anka be bia yaduri and ye wie kodadada.
Oh, okay. So,
yeah. Re-examination, I'm sure, say, court, it was just to accommodate them and let them move on. And yes, say, there was the need for it, in my humble opinion.
Okay. Yo, and what we'll do, ne say, Nyame Adamo China, say, court, ne site, na say, we are near best science ready in Comobio. Why?
What dama, me pato, yen say, Yamini Yabre.
Mate, Medasepa, Yamisha. Nti lawyer Nana Eje Bafo Ewua, a private legal practitioner, and Moten and Kano. Two very important points, and were raised based on cross examination. Of course, fortunately for you,